I have a small prayer. The matter which was withdrawn on Friday last month, we filed the case. Can it be
Yes.
motion?
Ah,
The motion cooperative society which was cancelled.
when do you want it?
As your losses time permits, if possible.
You have it on Wednesday?
Can it be
My lordship, I beg to mention regarding WPC number 2404/23. In earlier occasion, your lordship was pleased to issue notice. Accordingly, step has already been taken, service completed. Matter is pending, maybe on Friday, my lord.
It will be on Friday, the 17th of November. Before vacation, I'll not allow. it.
17th
Yes, yes.
of life.
Before vacation, no prayer will be allowed.
My lord, one eviction notice has come, my lord, and I have filed one writ petition on last Friday, my lord. Now giving us only 7 days time. 7 days time is already going to be over, my lord. Can it be on Wednesday, my lord?
Yes.
Obliged.
May it please your lordship, my lord. I beg to mention for listing of two matter of GST application cancelled on Wednesday.
Motion.
Motion, listing for motion.
Yes.
Obliged.
Please, your lordship, may I pray for listing this matter? This matter is urgent, my lord.
What is listing for what?
Listing for my lord, perhaps it will come in order column, my lord. Because
No, you have to tell me.
service complete, I have taken a step.
What is the matter about? What is the matter?
Matter, my lord, my account, my lord, has been fixed by the bank authority, my lord,
Hmm.
without assigning any reason.
So when do you want it to be posted?
My lord, on 13th February.
Yes.
Obliged, ma'am.
Daily list for motion, I think one.
earlier order is there, your losses cited, to take instruction. We have filed them.
Yes, who's appearing? What is your instruction?
Instruction awaited, lordship. Communication has been made. I am for 1, 2, 3, and 4, lordship. Abhayapuri Municipal Board.
Why I waited? It is,
Yes,
it was, order is of 20th of September.
Yes. 1 week time may be granted, lordship.
Then we'll have to call for personal appearance. Who is to give you instruction?
After two, yes, lordship.
Who is to give instruction to me?
District Commissioner Bongaigaon and Sub.
SDO. Not some.
One last opportunity to obtain instruction. Friday we'll post it.
Yes, yes.
I had Mr. James Savalar and Senior Counsel appearing for the petitioner. Ms. S. Burwal and Gia, some missed that instructions as called for from the District Commissioner Bongaigaon is still awaited, and therefore she be granted one last opportunity to obtain instruction by posting the matter again on 13th of October 2023. Prayer allowed as a last chance. If the respondents fail to respond to the requisition made by the learned government advocate Assam by the next date fixed, this court will consider directing personal appearance of the concerned officer to answer the queries of this court. A copy of this order will be furnished to Ms. Borwa during the course of the day.
Abhayapuri Municipal Board also appeared, have to appear, lordship.
So you obtain your instruction from
Yes,
the
sir.
district commissioner, that's all.
I did two.
Concerned officer.
Please, your lordship. This is a matter, my lord, where I had challenged a notice issued by my lord, the chief executive officer of the Jilla Parishad, my lord, for my lord, calling a non-conference motion against the petitioner, my lord, the president of my lord, the panchayat, my lord, Ka Panchayat, my lord. And my lord, one of the issue was, my lord,
Yes.
that my lord, two of the members, my lord, had my lord, 3 child, my lord, which were born afterwards, my lord, and therefore, my lord, they stand disqualified. That is one of the ground, my lord, I have taken, my lord. The other point, my lord, was that, of course, my lord, the chief executive officer is not, my lord, the authorized person, my lord, to issue such a notice. And thirdly, my lord,
Who is the authorized person?
my lord, it's my lord, the deputy commissioner, my lord. The deputy commissioner, as per the my lord, but then my lord, there are other issues, my lord, which I had my lord raised, my lord.
Meeting has been held on 30th.
Meeting has been held, my lord. The resolution has not been, my lord, given effect to, my lord.
What is the resolution?
We have not, my lord, got the resolution, my lord, copy.
Yes, who is appearing for the?
My lord, I am appearing for the private respondent lordship.
Hmm.
As per lordship, schedule of the notice, a meeting has already been held on 30/9/2023. And that decision is kept pending. On the other hand, lordship, all the members has given vote against the lordship, no confidence. Lordship. And presently, this is the ground what my friend has taken, lordship. So for the jurisdiction of the CEO lordship, chief executive himself. That power lordship, the deputy commissioner can delegate as per section 138 lordship. If your lordship kindly.
Well, the deputy commissioner has the power to delegate, my lord, only, my lord, with regard to meeting, my lord, to be held by under a gazette office, my lord, but not the, my lord. Not-
Section
he can
138,
Yes, delegation can be to the effect of presiding over the meeting, my lord, only.
not to that,
Section?
138 lordship of Assam Panchayat Act 1994. Relevant is clause 3.
So that is delegation of power by the state government to the.
No,
deputy commissioner.
clause 3 lordship, subsection 3. Now the second ground that has taken lordship, so far the issue of 3 children, this 2-member lordship has already resigned, given the resignation.
They are parties here.
They are parties,
Hmm.
but I
The
have the
respondent
copy.
numbers?
My lord, respond.
Respondent number lordship 8 and 10.
8 and 10.
So how many members in total?
Well, total 10 members. Out of 10, one has been lordship elected as vice president,
Hmm.
and 9 remains. Out of 9, 2 has lordship given the resignation, and out of remaining 7, all the 7-member lordship, as per my instruction lordship, they have casted vote in favor of no confidence.
My lord, the requisition was by 8, my lord, not by 9. Requisition was by 8, my lord, out of them 2 are disqualified, my lord. So 2/3 of the total members.
That's
my lord,
right. The two who are disqualified
My
did
lord.
not participate in the proceeding.
My lord.
Then there is no.
They did,
problem.
my lord. In fact, the requisition was also by them, my lord,
No, requisition can be. That is
Requisition was
a
them, ma'am.
different thing.
because it's per total of, my lord, 1/3 to. of the
So
total
are you
members.
saying that
2/3 of total
the
members, my lord.
respondent number 8 and 10,
My lord.
they did cast their vote in the no confidence
My
proceeding?
lord, that of course, my lord, my learned friend, my lord, I was maybe very better position to state, my lord.
I have the copy lordship, they have given the resignation.
What is your instruction?
For deputy commissioner, so SC, PNID are directed to elected commissioner.
So far resignation is concerned.
8 and 10 have resigned, that's what he's saying.
That's what he said, my lord, of
So
course.
that's the. So that ground goes.
So my case is, my lord, that had the, well, these persons were disqualified, my lord. So therefore, 2/3 of the total member had to bring in the resolution, requisition, my lord. So it is 7, my lord. So out of 8, my
So
lord.
where is it said that?
Yes, my
two-third
lord.
has to be-
Yes, my lord.
1/3.
Sorry, 1/3, not
1/3
1/3,
is-
my lord, 2/3.
Where is
2/3
it?
is to be
Which
casted
provision?
vote in favor of the
Mr. Datta, which provision?
requisition 1/3.
Oh, sorry, my lord, 1/3, my lord, sorry.
Then,
2/3 is the court cast their vote, my lord. My lord, that apart, my lord, my other cases, my lord. Here, what happened, initial requisition, lordship will see, my lord. Initial requisition was against both the president and the vice president. my lord.
Hmm.
Now that requisition, my lord, as so far as I was concerned, I had challenged, my lord, the notice which was issued subsequently on the ground that the, my lord, BDO was not an authorized person. They conceded, my lord. That notice, that meeting was, my lord, set aside, my lord, the notice was set aside. Now, my lord, the vice president, my lord, vice president is against the vice president, my lord, the meeting failed, my lord. Now, my lord, my case is, my lord, there should be a fresh requisition because, my lord, the process is totally different. Once it is against the, my lord, president and the vice president, my lord, it has to, my lord, the Anchalik Panchayat directly comes in the picture. Lordship will see, my lord, section 15, my lord.
no, Mr. Datta, we'll examine, but I am not continuing the interim order because the majority has voted against your
My lord.
client. He cannot cling on to the office. She cannot cling on to.
But,
the
my lord, lordship, my lord, I'm challenging the requisition also, my lord, notice itself, my lord, because notice lordship will see, my lord, the 15(5), my lord. It is the deputy
So she
commissioner.
cannot continue in office.
My lord.
So subject to that, you ask for a relief
My
which can be given. She cannot continue in office. This is a democratic process. majority has voted against her, she has to go. Merely by raising some legal issue, we not allow her to continue.
My lord, then Lordship will, my lord, fix an early hearing of the matter, my lord. Perhaps that's the only way out, because otherwise, my lord, my case is because, my lord, the CEO, he doesn't have the, my lord, power to issue the
The
notice.
prima facie, he has shown that deputy commissioner can delegate. his
My lord,
power.
Lordship, the specific provision is there in 15(5), my lord.
No, Mr. Datta, it's a democratic institution.
I understand, my lord. I fully understand, my
So
lord.
everybody who's been sought to be removed
My lord.
will come up, will engage a good lawyer and come up with some technical
My lord,
point
my
here
lord.
and there.
My
But
lord, but
that can't be, unless something is so fundamental
My lord.
that it goes into the root of the matter. the
My lord, there is a
courts will
judgment
not
of the
interfere.
Honorable Court, my lord, which says, my lord, that if there is even a little bit of infraction also, my lord, since it's the consequences, my lord, of the elected president, vice president, my lord, is serious. my lord.
What is the infraction?
My lord, infraction, my lord, even if, my lord, let's say, my lord, the power is, my lord, since, my lord, the power here, my lord, section
When are
15,
panchayat elections due?
15(5), my lord,
Panchayat elections? When are the panchayat elections supposed to be held? The PNRD council is not present.
because, my lord, the meetings are under specific provisions, my lord, 15, my lord, 15(5), my lord, the deputy commissioner's power is, my lord, prescribed, my lord. He has to convene the meeting, my lord. He can only a deputy officer or gazetted officer, my lord, to preside over the meeting. But here the meeting has been convened by the chief executive officer. And secondly, my lord, as I have, my lord, submitted, my lord, the process has to start afresh because earlier requisition one part had failed. Now, my lord, since, my lord, the 50, my lord, section 15 makes it very specific, my lord. If the my lord, requisition is against the president, yes, the notice has to be given to him, my lord.
No, I will examine that
My
point,
lord.
but that will not give you a right to continue in office.
But if the entire process itself, my lord, from the initiation, my lord, is bad, my lord, because here, my lord,
Is there any case law in support of your argument?
my lord,
he
my
decided
first submission, of course, my lord, is that, of course,
You
here.
have to
this-
make out a prima facie case.
Yes, my lord. My lord, my first submission is, my lord, here. Lordship will kindly see your section 15 once.
No, there is no decided case law in favor of this.
My lord, on this point, no, my lord. Because here is a different issue. What happened initially, the requisition is against both president and the vice president. Against the president, my lord, both of them came before this honorable court. So far as the vice president is concerned, my lord, that resolution that failed. So far as I am concerned, my lord, this honorable court set aside the requisition. My lord. And my lord, that fresh, my lord, process should be held as per law, my lord. Now, my case is, my lord, since now it is requisition only against the president, not against the vice president, my lord. The 15(1) it has to start. Where I get an opportunity to hold the, my lord, convene the meeting within 10.
Yeah, but did you argue that point before the?
No, because
Court last
this
time.
is a new development, man. This development was not there because the resolution against the vice president failed on a later day.
Hmm.
And
But the vice president is no longer in office.
no, he has now become the president, my lord. That's what they're trying to say, my lord. So therefore, my lord, the situation scenario has changed later on, my lord. Therefore, that was not a case which I could have challenged at that point of time. Now, my lord, since
No, Mr. Datta, where is the last order of the court? Let us see the.
yes, my
operative
lord,
part.
there, my lord, yes,
Which page?
yeah, my lord. Lordship's order is at page 31, my lord.
Hmm. So last time the meeting was convened by the BDO.
BDO, my lord.
That
they
was set
considered-
aside.
That they consider saying that he's under power.
Yes.
That was his right.
Yes.
So for the president, vice president is concerned, my lord, Lordship will find that order at page 57.
Page?
57.
No, but order in page 31 is pertaining to your client.
My client, my lord.
So the only point was that the video could not have convened the meeting.
Yes, that's because, my lord, this point now I'm urging, my lord,
Hmm.
that the process is to start afresh. This, my lord, comes into force, my lord, only after the vice president's election has paid, my lord. Earlier, since it was against both of them, my lord, lordship is the requisition, my lord. Sorry, notice, my lord.
Hmm.
Earlier notice, my lord. It was against both. That is lordship will find at page 22, my lord, 28.
So these are all separate notices for all purposes have been put together in one notice. These are all in the form.
My lord,
In
no,
substance, the decision is to move no
right.
no
my lord,
confidence
right.
against both the
My lord,
persons.
what has happened, my
They
lord?
could have given two individual
Yes,
notices.
yes.
They've given it in one.
Yes, now what has happened, my lord, what the law says, my lord, is that if the requisition is against both president and the vice president, then, my lord, the matter directly goes to the Anchalik Panchayat.
Yes.
Now, since now it is only against the president, my lord, it has to start from the Gaon Panchayat itself, my lord. The notice has to be, my lord, has to be brought to my notice. Then, my lord, if I don't convene a meeting, then only the Anchalik Panchayat.
We'll
comes to the
dispose it
picture.
of on Thursday. Come prepared also.
My lord.
Heard Mr. M. Dattal on it, counsel appearing for the petitioner, also heard Mr. S. Borwal and G. Assam. Have you received instruction?
My lord, as far as the PNRD department stand is concerned, last time, my lord, in the order had observed whether the requisition notice still stands valid, since it has not been set aside by the previous order of the coordinate bench
You argue on Thursday.
Thursday.
That's the Mr. P. Hendik for the Learned SC PNRD Assam for respond numbers. Milay Lava and Mr. M. Khan, Learned Counsel for private respondents. After hearing the preliminary submissions of Learned Counsel for the parties, this court is of the opinion that the matter would call for expeditious disposal. Register to therefore list this case again on Thursday for admission hearing as a fixed item. All parties are served.
My lord, these two, lordship, those are resigned, lordship, they have not.
Then issue notice returnable on Thursday since respondent so and so. You are not appearing for all private respondents.
No, lordship. These two resigned members, lordship, are not before this.
Correct. Since the respond numbers 8 and 10 have already resigned as members of Gaon Panchayat, their presence will not be necessary for the purpose of the final disposal of the petition. As such, register to list this matter again on Thursday for admission hearing as a fixed item. Interim order passed earlier to continue till then.
My lord, diplomat.
Lordship matter pertaining to ex gratia, your lordship. Here lordship petitioner are the next of kin of the your lordship of the deceased, namely late Jatish Ranjan Dev, your lordship, who had expired in a road traffic accident on 24/10/2017, your lordship.
The petitioners herein are the next of kin of late Jatish Ranjan Dev, who died in a motor accident which took place on 24/10/2017. As per the standing government circular dated 15/11/2014, the petitioners were entitled to receive ex gratia compensation. However, since their request has not been acted upon by the authorities, the instant writ petition has been filed. Upar naam to the so and so for the petition. Issue notice returnable in 6 weeks. Since Ms. G. Hazarika, Learned SC Revenue Department, Assam, has appeared and accepted notice for respond number 1. Mr. Who is for finance? Mr. H. Alia, Learned SC Finance for respond number 2. And Mr. S. Borwal, Learned G. Assam for respond numbers 3, 4, and 5. Service of notice will be completed in this case.
Lordship, I have another prayer in respect of item number 9.
Same.
Same lordship. They are also the next of kin of the deceased.
Who is the person who has died? What is
Wife in item number, in respect of item number 9.
syllabus? Part 2, item 9 also.
Obliged.
Any person? Get to number, that's synopsis.
Lordship, please.
Lordship, kindly matter may be passed over for the time being, Lordship.
What is the matter?
Lordship, this is in regards to a license fee that has been recovered from me. I am aggrieved by the demand notice which at page 106. Now, the authorities have calculated the period from 2015 to 2023. The license fee based on 7%, but on the current value. Whereas the notification and the guidelines of the railway says that you can correct it 7% on the previous lease. That I have quoted at page 23 of my writ petition, the calculation, which is their own guidelines. So they have gone and charged 7% on a present circle rate. Therefore, the amount has gone to 58 lakhs. Whereas the amount of 7% which I'm entitled to pay in terms of the previous lease is around 5,54,000, which I'm already agreeable to pay. I'm not in dispute on that. But now they have gone and calculated basis in a completely erroneous calculation. That's at page 23 also. I've already given the calculation.
Why do you want it, Pastor?
Lordship, in this matter, K. Gogol is supposed to be appear, but he's on legs, Lordship. Okay. Item 5.
May I please, your lordship? My lord, an order dated 19/7/2023 is under challenge, my lord. My lord, by which, my lord, we are the, my lord, members of the board of directors, my lord, of the Losanabari Samabay Samiti Limited. My lord, had been elected by following a due process of law, democratically elected. Now, basing on an appeal, my lord, filed by the previous secretary, the entire AGM as well as the board of directors, my lord, had been set aside by the registrar, my lord. That, my lord, is
Where
under
is the order?
my lord, at page my lord, 85, Annex 10, my lord.
What is wrong with the order?
My lord, the wrong with the order is that, my lord, the ground which the register has shown, my lord, that the election was held. My lord, at page 86, kindly for a moment, my lord. It is seen that the AGM oblique election of so and so held on so and so with the first agenda is election. The other agenda AGM were held after election as per clause 3E of the Assam Cooperative Societies Election Rules 2019. The other agenda of the AGM should be completed within 12 noon on the date of AGM, and after that election be started. Now, my lord, what was the basis of this finding? Nothing has been, my lord, said in this order. And as per the, my lord, rule, the election was held. If my lord may be pleased to take up the AGM oblique election which was held, my lord, is on 20/12, which had been accordingly approved by the, my lord, Assistant Registrar Cooperative Societies Morigaon by, my lord, examining all the relevant records and the proceedings of the AGM oblique election, my lord. But the registrar, my lord, wherefrom he has found that the AGM oblique election was held beyond the time limit, that is not there, my lord.
My lord, this is an order of 19 July. In respect of the same order, my lord, another writ petition is pending, my lord, 5364/23. In that case, notice has been issued, no interim order passed. So both the matters may be taken up together.
Now, who is running the affairs of the committee?
Departmental officer, pursuant to this order, my lord. he is-
One man committee has
Yes,
already.
One man has been given, but my lord, it is a, my lord, with all respect to my senior friend submission, my lord, that yes, there was an earlier writ petition was there, my lord, I cannot deny. And another writ petition, I have also annexed the copy. Notice was issued and the, my lord, interim order was directed to be considered on the next returnable date, but that has not yet been listed. So, my lord,
Which is the other writ petition?
my lord, at page 87, Annex 11 is the next
87,
one, my lord.
Abdul Rahim, no? Abdul Rahim, no?
Hmm.
5364 কি আছিল?
সেইটো বেলেগ, সেইটো মোৰ নহয় বিবাহ।
All right, we'll issue notice here also.
My lord, my lord.
Same number.
Heard Mr. A. Bhuiya, Learned Council appearing for the writ petitioner, assailing the order dated 19/7/2023 by means of which the election of the board of directors of Losanabari Samabay Samiti Limited Morigaon held on 22/12/2022 has been declared to be illegal on the grounds stated therein. Mr. Bhuiya submits that the ground on which Mr. Bhuiya submits that the impugn order is vitiated by perversity and hence liable to be set aside by this court. Mr. S.K. Talukdar, Learned SC Corporation Department, Assam, appearing for the respond numbers
My lord, 1, 2, 3, 4, my lord.
1 to 4 and Mr. M.H. Ahmed
I am for the cabinet or lordship. I have not,
and counsel for the respond number 6.
not my lord impleted lordship.
You are not
I
impleted.
filed cabinet lordship.
Who are you? Who are you?
My lord shareholders, my lord, they have filed another. petition.
Shareholders, you can't file. You have
My
filed.
lord, Another petition, my lord, that is pending, my lord.
We'll see, we'll see.
5364.
Achha,
My lord, already, we have no
1 to
objection,
4.
lordship.
Raise for some time to obtain instruction by submitting that similar writ petition assailing the same impugn order is pending before this court in the form of WPC number
4742.
4742/2023.
Another is pending, 5364/23.
As well as 5364/2023.
Another is 55.
In view of the above NOM 4 weeks, Since Mr. Talukdar has accepted notice for report numbers 1 to 4, no formal notice required to be sent to the said respondents. Extra copies of the writ petition be furnished to the Learned Standing Council. Petitioner to take steps for service of notice upon report numbers 5 and 6. Heard on the prayer of interim relief. The paid prayer will be considered on the returnable date. Register to list this matter along with WPC number so and so and so and so after 4 weeks.
My lord, another petition lordship, 5517, my lord, that is also pending lordship, same subject matter lordship.
Let's see.
That
Let it
also
come.
my base in the village.
What is your urgency?
My
Let me
lord,
stay the order then.
Or look at the lordship.
Yes, next matter.
Oblige, my lord.
Item 6.
May I please your lordship?
Yes.
Lordship, here in this writ petition, lordship, I have challenged the order dated 7 September 2021, lordship, page number 28, by which lordship the petitioner has been removed from the post of ward member, lordship, on the ground that
On the ground,
the
more
petitioner.
than 2 living children.
Yes, lordship,
We'll have to issue notice. Where is the order?
page number 28, lordship. My ground is that, lordship, these sections are not applicable in my case, lordship.
All right, notice has to be issued.
Yes, lordship.
And the order can be set aside,
Yes.
but there can't be a stay.
Yes,
Page number 28, did you say?
28.
Yes. Heard Mr. M. Ahmed like counsel for the petitioner. Peruse the amendments made in the writ petition. This writ petition is directed against the order dated 7/9/2021 issued by the Deputy Commissioner Karimganj, removing the petitioner from the post of ward member of
Ward number 6,
Ward
not
number
Karimganj
06.
Gaon Panchayat.
of North Karimganj Gaon Panchayat on the ground that she had more than 2 surviving children as on the date of her election. We'll stop here. Mr. Ahmed submits that So the notice says, which is pending this, the period is between 15 to 23. The total land license of financial year 15-16 to financial year 2023-24 amounts to 43 lakhs, which is excluding GST. 18% amount is 6 lakhs in the interest and 15 lakhs is the other interest part of markets. Now, the calculation based on which they are doing, the losses are mentioned at page 23 of my petition. So what is the land license? You are occupying land of the ABS. I am occupying a land in which I have factory built for this is for monocoques for the railways. Since 1989, it's a lease rent line which you have to select from me every year. The lease rent from 1998 to 2014 is also set. The board is in one phase.
that they have demanded some extra money that has already been adjusted. The period from 2015 to 2023 is a very potential.
So Mr. Bhupan, how this liquidity is maintainable on the,
Because the calculation that the areas are.
is there a lease agreement?
Yes, there's a.
Is there an arbitration clause in there?
No, there's no application for it. May I just read page 28 for a minute? So, para 23.
You have to seek a declaration before the civil court. No? What is the 226 element in this?
So the demand notice for the period is where it's sitting. And this is an authority.
Only because railway is the authority. That's why you have filed the writ.
No, no. Your worship,
Supposing it was a dispute between two entities.
yes.
Would you have filed it with your civil court? So the dispute is such that it is not a matter to be decided.
I say that another odd matter in which your lordship, the High Court has already passed an order in similar.
Apart from that, any other argument? Any other argument apart from that?
The only thing is that the calculation is completely wrong. That's why I said it at page 28. The calculation of 7% in terms of.
Who will do, you expect the High Court judge to go into calculation of your license fee?
May I just pass on this worship? It might be clear.
See, Mr. Gogoi will admit it because you have never raised this plea and some other court issues a notice. That is their plea. So I am admitting it. Granting a stay and I'll record that. Mr.
Yes,
Gogoi has not
that's
approved.
the order, your lordship, says writ petition 3341 of 2018, recently passed.
Have you objected when the matter was decided?
Yes, but I even know what I said to it. Otherwise,
Then we'll record in the order. The council is not objected to.
lordship says clear and indicated a disputed fact.
Yeah, but you did not, your council, the railway council did not object when another court admitted it.
Another court that.
Yes, yes, yes. Another court. That's the only ground. Otherwise, it's not maintainable. But your panel council don't point out this thing. And we cannot take divergent views.
That's part mostly I cannot. And then object.
Where is the order? Show me and only on that ground. On that ground. I'll mention it in the order that when the matter came up before that court, railway council did not question the maintenance.
There was a copy. At 7%, I think the regulation is. As per their order, I cannot find it. At the 7%, your lordship is by law, by the regulation.
You pay 7%.
Yes, I'm agreed to pay 7%, which I've already said in the representation also in my written petition. I'm ready to pay. That your lordship. I have said it.
Within how much time will you deposit the amount?
Yes, the amount is page 33, your lordship. I've already said in the reception.
Where are the demand notices, page number 1052?
Yes, the final demand notice is 105, which comes, the already other demand notices will come into place. This is the last one to be issued.
Or Mr. Abid Patel has asked to there is a final demand notice which is 20,000. Usual indicator. So, 1 year. So, raising a demand of 68 lakh 80,710 plus this as land license they will register for using the land of the railways. It has become something that the as per the agreement subscription between parties, the petitioner's liability is only to the extent of paying license fee at the rate of 7%. 7% of
The lease when collected on the last year.
7% of the lease
When collected on the previous year.
when collected in the previous year, but by the meeting demand notice, the amount has been raised and probably in a most arbitrary manner. As such, Mr. Uppan further submits that his client is willing to deposit the amount as per the agreed procedure, that is 5 lakhs 59. Within a week from today, but the meeting notice is contrary to the terms and conditions of the agreement. Because by a copy of the order dated 20/1/2022. Passed by this board in WPC number 334. In a similar dispute with the respondents. Very. Interfered with the improved demand. We don't want. No, you receive notice. After you receive something, you went there and take something. What is it? Then I have to 5 minutes to argue. After that, I'll pass you. Till this cannot be satisfied. Mr. Ishaq Mani Council submit that he failed it. He registered deed of sale for known property. And the challenge is I have according to the clear that is council there, but there should be some mechanism under the law which permits you. I approach the capital to get the first case 41 year old. Father, son, I want, I don't want you, I want to meet my. That is the only thing you want. Your brother doesn't want that only thing to happen. But I'm asking you, how is this matter coming within the domain of this jurisdiction of the because he is under his perspective. What is her position that he is not in a position to talk? Not only my rights, her right also be violated. So when is the plan? He will do it. He wants to come. This is a different from the Dubai. Then we have to first issue notice to the other side. We have to figure out how to do that. What do you have to say on this? Thing is that that's the fingerprint section. What he may be requiring the assistance of police to go and look for other. So on that part, he has made it clear that that particular time it was made in the month of this is murder, not a crime. That's not a crime. But for that matter, there has to be a map from the party. So let us see. Let us serve notice. Yes. We'll find out why he is not allowed to. Justice I will also permit you. But we say it when Timothy? Vidya Devi. Vidya Devi. He is ready to residing into the Nova. what is the below? My department said below no action has been taken. Police can register FIR only if there is a related to the public below. My lord, show me from your FIR what public fine. Just take me to that one sentence in your FIR at page 11. No need to read your FIR. I lost one sentence. I'm reading the correct. You show it from the page 11, but one sentence, which according to you constitutes the public below. The last line. Why the police said they trespassed my house and assaulted my leg by stone and the accused number 2 got my leg to kill me and broke down the leg of my cow by a piece of wood and refused it to kill me. Because I am a witness of some incident. The police took my mobile phone number and recorded my name. So breaking down leg of your cow is a punishable offense and the people assaulted my leg. Assaulted my leg. And assaulted on my leg by stone. On your leg by stone is the offense under which section? So there is lady was in lady was still melody on topic. What do you have to say? Post it next week. Okay. No date of no date. No the first of 19/8/2015. Where does not find the date? The case 1911. Sorry. So FIR is in page 14, not 11. But in case 13 that the incident was 19/8/2015. 1 month of me Nivedam is why you have to use the 14, 15, 16 and 18. 11. 18 will be taken. 15. My lord, earlier also notice was issued. Up to this Honorable Court, and this Honorable Court was to stay the eviction process, ma'am. The Honorable Court has passed the order in of page 31. Last by in the interim, take that 11, 10, 11, 22, till final disposal of the case. Now, my lord, the other day on 4th October, the earlier decisions were listed, and the application was made from the revenue side, yeah. All the mistakes will be thrown up. And accordingly, those someone has filed IMI. Those IM were closed from producing the document of footwear level. In respect of us, we have still now not issued. So we are
May I check that the information which is being furnished by the public that the notices will be withdrawn. They have already received, two petitioners have received the withdrawal notices and few petitioners were yet to receive the withdrawal. In this particular case, I think there is stated that you are directed to vacate the state within 6/10/2022. Today is 9th February. 100% this is also being withdrawn. So a lordship may kindly fix all these matters along with the after.
Yes, absolutely. The withdrawal of the
If this particular notice is not that the been withdrew, then they would have been affected because they were already allowed to six of. If we go by this. Tell us on Friday. We'll fix it on Friday. So, to go by this notice, is given, Your Lordship, this notice was issued on 22nd of September, page 36. This was issued on 22nd of September. And there, in 22nd of September, and there they were directed to vacate the land within 6th of October. So few of the cases already withdrawal notice, that is what I'm saying. Why don't you inform us to Friday? That day the submission, absolutely. That day the submission was given by government advocate that the persons who did not receive the withdrawal notices, they would also be furnished the withdrawal notice in the due course. So the cases were listed on 4th of October. So today's 9th of October. I have a decision. It is assumed that they are withdrawn because then you tell us with both these matters. You can't ask demand matters to be kept pending in the case. That's what I'm saying. Why don't you often instruct and enforce this case? We'll fix it day after tomorrow. After tomorrow? Day after tomorrow. Yes, it is a period cannot be with them. It's already unjust. Anything may happen. Which are the cases? I can either 14, 15, 16, and 18. But from the month of September 2022, that amount has been stopped. Now we are doing what the third basis about rolling around the officer, but no reply that is forthcoming. That why that amount has been might not have verified from the bank details which I have annexed at page 26. Yeah, you are asking to apply.
There are page 21 of the rectification list. Page 21. Clause 1, subclause 7. I'm reading them. The chairman, vice chairman, and the other members of the PIC Development Board shall be nominated by the state government. They shall hold their position in the PIC Development Board at the pleasure of the state government. The government may at any time change the chairperson, vice chairperson, or any member of any PIC Development Board, or may dissolve the PIC Development Board, or so this basically these are all 3 years for that particular board, not for the chairman or the vice chairman or the member. They are all appointed by the pleasure, doctrine of pleasure, man. That's what I appreciate. But even then, there must be order, I may not be entitled to so positive. If there must be written order, must basically taken up. Doctrine of pleasure, nothing. No, man. There is no notice, but there is nothing in it. Minor, that's the first one. Because minor, the other has not doing that. Still I am confused. Doctrine of pleasure, the court cannot interfere. That is how you came in. No, mind. That is how you have to go. Yes, I agree. When I have to get and go, doctor will appeal to them and find out some kind of order. Fortunately, my is over order. Page 24, man. There are so many other appointments which happen in the pleasure of the government. Nothing like this. It's not to be under no, that argument is not. Doctrine of pleasure, there is no sticky. No, man. There some election there, at least my lord, such cases came up before this court, and those bunch of writs which are dismissed, then it can be appealed. There are 20 bills by development corporation. My lord, writ will file, all dismissed. The court held that particular pleasure to not. Court may not interfere, but court cannot interfere. It is right to submit. That is always there. That's hard to do. You are free to argue whatever you want, but you also know what order is coming, and you also know what is coming. You are entitled to make your argument. Here, my paragraph 22. There is a distinction between doctrine of pleasure as existed in the legal setup and the doctrine of pleasure in democracy governed by rule of law. In a 19th century legal setup, unfettered power and distinction of the crown was not an alien concept. However, in a democracy governed by rule of law, where arbitrariness in any form is no government or authority has a right to do what is pleasures. The doctrine of pleasure does not mean a license to act arbitrarily, capriciously, or whimsically. It is a presumption that discretionary power conferred absolute and unfettered terms on the public property is necessary and is accessible reasonably and for public. Reasonably, they have to move. That's no part. So, to come, then, my lord, paragraph 55. Paragraph 35 of your issue. No monument. That's judgment. This judgment is not. I am supposed to have. They have the power, man. Don't know that. Why are they tomorrow somebody will go, day after tomorrow somebody will go, man. There must be written. For the development, how politically they have to move, how they do the development.
Doctrine of Peter, however, is not a license to act with unfettered discretion to act arbitrarily within the state. It does not dispense with the need for a set for a cause for the withdrawal of Peter. In other words, as Peter doesn't enable the removal of a person holding office at the Peter of the authority, summarily without any obligation to give any notice for hearing the person removed, and without any obligation to assign any reason for excuse any cause of the removal for withdrawal of the the withdrawal of Peter cannot be a simple game and see of the authority, but can only be higher value. That's the 9-1. What is that? Then I 72 matter. The traditional English view was the prerogative power of the crown conferred on the decision which could not be questioned in court. Lord Ruskin attempted to enumerate the progressive power of the Council of Civil Service Union versus Minister of Civil Service. Prerogative powers such as those relating to making of treaties, the defense and the event, and the provision of mercy, the grant of honor, the dissolution of parliament, and the appointment of ministers as well as others are not, I think, justiciable to the judicial review because their nature and subject matter are such as not to be amenable to the judicial process. The court are not the place wherein to determine whether a treaty should be considered for the armed force disposed in the particular manner or the parliament judged in the dead rather than another. However, the contemporary English view in principle event, such political question and excessive political power will be subject to judicial review of legality, rationality, and possibility into the judicial review. They are always decision of the mind of the removal of the petitioner mind in the basis of the regarding the removal of a governor, the governor. You must have seen the last subparagraph of para 80. You are not ready. Last subparagraph of para 80. Subparagraph 4. Last page, my lord. There is no need to assign any removal, as there is no need to assign religion and removal of the consequence of the girl that will be achieved to very consequence to a limited decision. If the active person is able to demonstrate Brahma visited this removal was acted as a to fall upon the income, disclose the food, the metal of the good person has taken the decision which is the freedom. If the Union government does not discuss an income to the region, schools are found to live and to the city of the food to the. So you have to demonstrate that you are suppose my lord, some suppose if some I must be able to say some delegated my people or some kind of my lord where I have not able to perform my duty to the side. They do not come into me. My duty as a chairman to distribute the particular religious skills coming, I should contrast to the other members. If I fail, legally my lord, I should be no my lord, but mistakenly my lord, I have just 1 year, 8 months and 14 months to go. There is no funds coming, no development, nothing that I have done. Just enjoying the food. Nothing. What kind of my lord you can down? If there is something my lord problem is I have not done or there the education that I have done corrupted or something to do. Just mere figure my lord without anything I have to do with that. That's why there is a mass decision there, two medical that we have done that will be correct. My because the other person has not paid. That's why my lord. And except this judgment on the matter of what I was surprised to the market it's in the three plus in the hoping to complete the whole market. All right, I have Mr. Standing council that
Private development.
No, my lord, it's tribal issue.
Department of Private Development.
My lord, one twin.
Doctrine of pleasure is very, 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 very.
My, I
In
know
that
that,
case,
my lord.
the
I know
Supreme
that
Court did not
amendment, my
prescribe.
lord, it is allowed, my lord. Tomorrow again he will be sent
You
by.
cannot be appointed. That question has to be first gone into that. What is the reason for your appointment? We'll go into that. Pleasure is like that. Who comes in, nobody questions. Who goes in, nobody questions.
Development,
We will, when we examine this case, we will first go into on what basis you are appointed. Because if you reopen doctrine of pleasure with reason, then all these things will come in. Pleasure means no reason. It's completely discretionary. You have enjoyed the fruits of that while entering. Now while exiting, you want reason.
Then
That's the
where
law.
this statutory body chairman has been appointed on the doctrine of
Absolutely.
pleasure, my lord. That development is not forced, my
They will
lord.
challenge that notification. Actually, moreover, the notification dated so and so is not in the cell. Before rejection. You have not challenged that notification. They say it is permissible.
That's why I'm praying for the region, that must be the region, why they have my lord. Or it's a stigma for my political career, my lord.
Absolutely nothing. Mr. Saranya, every advocate general who is appointed and removed, will then come and say it's a stigma, I can remove. These are all done by doctrine of pleasure, every government advocate, every standing council.
Government go advocate general.
No, even in the same
Yes,
government,
okay, my lord.
even in the same government, there are removal. Then they'll say it is a stigma, then nobody will be appointed. Where is the stigma here? The law of stigma is very different. And you check out and come and argue next time. Yes.
For improvement of the portion of excess as party respondent number 4 in the district.
How many IAs you have filed?
There are 3 cases, 3 IAs.
All commission of taxes.
Civil and
Sure, we'll allow it. Ask Mr. Ashok Land Council for the applicant also query the statements made in the IA. This IA has been filed with a prayer to include the commissioner of taxes as the fourth respondent in the connected. Mr. Sonia Lanet, SC Finance Department, Finance and Taxation Department, Assam is present and convinced that freedom no objection will be prayer for improvement is allowed. Similar to stand up, Mr. Who is the PWD?
Lordship, PWD, okay, H. Burwa.
Who is Burwa Lanet, SC PWD, appearing for the other responding sister. In view of the above, and considering the ground taken in the IE, the prayer of improvement stands allowed. The Commissioner should we have copies? Take on her list, I'm sorry, I counted for the applicant credit. By filing the interlocutory application, the applicant is to include the commissioner and secretary to government school education department as well as director of elementary education. As the response number 7 to connected with the direct SC elementary education have not appeared to approve the prayer made in the IE. So hearing the submission of knowledge package to the applicant their declared to include the opposite party numbers 1 and 5 allowed to be included as 4 and 5 connected with amended cost cycle of the institution which will be presented defined by the within a week from ISM. Circular respondent number 3 same my lord, here we are occupying my Sakari land. My lord, we have purchased my lord, we have finished the feed my lord and my Sumapandi my lord, is the Patta land. So in that view of matter my lord, the executive very much necessary
On the last occasion, it's like one private respondent have been made a party and they have also come up with the affidavit. But unfortunately, their name hasn't been reflected in the document. They are the civil people. Then my lord, but after puja, my lord, I shall find it my reply.
Mr. S. Chauhan, counsel for the petitioner submits that he is yet to receive a copy of the counter affidavit filed by the respondent number 3. First up. As well as respondent number 3 as well as the private respondent. First up. Today, the matter has been listed without reflecting the name of the private respondents in the cause list. In view of the above and on the request of Mr. Chauhan, let this matter again after the reopening of the puja vacation. Ms. G. Hazarika, learned SC Revenue, and Mr. S. Borua, learned G. Assam are present on behalf of the official respondent, registered in this case by reflecting the name of all the council and the cause list. Interim order passed under to continue. And you know, the last order passed about Mr. Sava and Mr. Musawa is telling us about the BTG to obtain instructions. Extra copies have been served, or extra copies. You want a patta to be issued in your name, both the cases. Both the, is a settlement of a plot of land is a reducible. Since last 30-40 years, they are possessing that process. They have applied for a patta or settlement, and it falls under the BTC jurisdiction, my lord. So your lordship directed the obtain instruction, and please they have to apprise the actually status of my settlement, my lord, which is pending with them, my lord. Yes.
What's the BTC required, Lordship?
What has happened to SCBTC? I did not come to court because of water or something like that. SCBTC has not appeared earlier also. Both are. Heard Mr. J.P. Sharma, learned counsel appearing for the petitioner. In both these cases, also heard Ms. S. Borua, learned G. Assam, and Ms. G. Hazarika, learned SC Revenue Department Assam appearing for the official respondent. None has appeared for the BTC authorities, although the name of the standing council is shown in the cause list. This writ petition cannot be disposed of without instructions obtained from the BTC authorities. As such, since the learned SCBTC is absent today, let these matters be listed again after reopening of the puja vacation by reflecting the name of the council for the respondents in the cause list. It is made clear that if the learned SCBTC fails to appear even on the next date fixed, these writ petitions shall be taken up for final disposal on the basis of materials available on record.
May I please, Lordship? Lordship, before my learned starts, Lordship, my lord kindly see order dated 5/9/2022, last part, Lordship. Last paragraph, Lordship.
Yes.
Maintainability, Lordship.
Yes.
The fear for my lord eviction, my lord directly, private respondent, so far private respondent is concerned.
My lord.
Civil dispute, Lordship.
Well, no, my lord, this is article 21, my lord. In person, article 21, my lord, the petitioner may be protected his life and property, my lord. His father was martyred, my lord, in the Assam movement in the year 1983, my lord. Thereafter, his land, the patta land inherited by the petitioner, my lord. That property was encroached by the one Voxon Conservation Soil Conservation Office and 18 bigha 3 gatan 18 lakhs was incurred by the private respondent, my lord. So the Article 21, my lord, it is applicable for protection of the property, my lord. Of the
Who is for the state here? Respondent 1, 2, and 3. What is the instruction?
My lord, standing counsel, she is not well and she is admitted in the hospital, so she couldn't come. So can you please adjourn, the matter may be adjourned for a day.
Heard Mr. B. Islam, learned counsel for the petitioner, also heard Mr. M. Ahmed, learned counsel appearing for the private respondents, and Ms. S. Borwa, learned G. Assam for the respondent 1 and 2. Today, when the matter is called up, it is submitted at the bar that the learned SC Karbi Anglong Autonomous Council is unwell and has been hospitalized. As such, this matter be taken up after the reopening of the Puja holidays. Considering the ground on which prayer for adjournment has been made, same stands allowed. This matter be listed again in the second week of November 2023.
It has not been filed by the respondent.
Some more time required, Lordship, instruction yet to receive.
Petitioner's counsel is present on the request of learned G. Assam. This matter is directed to be
A date may be given, Lordship.
listed again after 6 weeks so as to enable her to obtain instruction file affidavit.
Obliged, Lordship.
Item 29.
May please, Lordship. Lordship, here, Lordship, there are two petitions, Lordship. Their parcel land has been using by the reservoir authorities, Lordship, the National Highway Authority, Lordship, without giving any payment compensation, Lordship. Or parcel land, Lordship.
Yes.
Lordship, they were directed to file.
Instruction has come before government and.
We have received some.
What is the instruction?
Gazette notification, the 3G Gazette notification has already passed, published, Lordship, on 17 to 23. And no construction was going on, Lordship, has going on in the said land.
You file your affidavit then.
Yes.
File your affidavit. Heard Mr. Ashok, learned counsel for the petitioner, also heard Ms. S. Borwa, learned G. Assam appearing on behalf of the respondent numbers 6 and 7, 6, 7 and 8, who submits that she has received instructions and be given 4 weeks time to bring the same on record. Ms. R. Bora, learned SC NHI authorities is present. NHI DCL is present on behalf of respondent numbers
245.
2, 4, 5. Ms. G. Hadarika, learned SC revenue for respondent number 3. And Ms. G. Hadarika, learned SC revenue for respondent number 3. None is appeared for respondent number 1. On the request of Ms. S. Borwa, learned G. Assam, let this matter be listed again after the ensuing Puja vacation. In the meantime, the affidavit on behalf of the respondents will be brought on record.
Item 30.
Please, your lordship.
Yes.
My lord, this matter relates to settlement of land under land policy 1989. Here the deputy commissioner has filed affidavit, and in the affidavit it is stated at page 40, my lord, of the affidavit that the circle officer of the Nagaon Sadar Revenue Circle has been instructed to verify and resubmit the proposal. So, and by the letter dated 16/6/2023, that is at page 56 of their affidavit, my lord.
So we can dispose it off?
Yes, my lord.
Page 40, which part you wanted to?
Page 40. the
Page
first-
40, my lord, fifth line from the top, my lord. Being not satisfied and the said re-verified proposal mentioned above, my lord, that the Nagaon, the additional deputy commissioner revenue, Nagaon instructed the circle officer, Nagaon Sadar Revenue Circle again to re-verify and resubmit fresh proposal along with requisite documents by letter dated 16/6/2023.
And what is there in page 58?
58, that is the letter, my lord, dated 6, 2017.
So this is a fresh proposal.
This is
it?
the fresh proportion because previously there were some discrepancies. Accordingly, that had been erased. And this is the fresh policy based on
So
the
now
light
this
of,
will be processed in accordance with law.
Yes,
That
yes.
your friend heard.
as
Mr.
per the new
Chaudhary,
land policy.
Senate counsel appearing for the writ petitioner. Writ petitioner, yes. Also heard, you are there? Is G. Hazarika Learned SC Revenue Assam appearing for the respond number 1 and Mr. S. Burwa Learned G. Assam appearing for the respond numbers 2 to 5. Full stop. The writ petitioner herein claims to be in occupation of a plot of Sarkari land measuring about
True cut.
measuring about 2 cutters covered by Dag number 302 of Nagaon town by paying Tozi Khazana since past several years. Full stop. Since the petitioner is a landless person, he had submitted an application for granting settlement of the land in favor of the petitioner. However, due to the inaction of the on the part of the revenue authorities to consider his application for settlement of the land, the petitioner has approached this court by filing the instant writ petition. Full stop. Mr. S. Borua Learned G. Assam has invited the attention of this court to the statements made in the counter affidavit filed by the respondent number 2 to submit that there were some discrepancies in the proposal for settlement earlier submitted by the concerned circle officer, that is the respondent number 5, as a result of which he has been asked to submit a fresh proposal for settlement after rectifying the defects. Accordingly, the respondent number 5 has submitted the proposal for settlement of land in favor of the petitioner on 6/7/2023, and the matter is under consideration of the authorities. Mr. Borua submits that appropriate action in the matter as may be permissible under the law would be taken without undue delay. If that be so, nothing further survives for adjudication in the matter. Ms. Chaudhary, Learned Counsel for the petitioner, has also fairly agreed to the said proposition. In view of the above, this writ petition stands disposed of by providing that the proposal for settlement of land in favor of the petitioner as submitted by the respondent number 5 be considered and processed in accordance with law. Be processed in accordance with law and be taken to its logical end as expeditiously as possible, but not later than 6 months from the date of receipt of a certified copy of this order. Consider to nalage with writ petition stands closed.
Obligement.
In a draw of lots, when that he was selected for as a for distributorship of the oil retail manner. Then at page 105, that is the selection manner. Page 105.
Yes.
Lordship, Senior Counsel, Mr. M.K. Chaudhary is on legs.
Nothing come. my lord.
Maybe possible for the time.
But
This is for final disposal.
yes, my lord, only ground is that he is an executive member, nominated executive member. So therefore, they are saying that we cannot be granted. Otherwise, in the draw of lots, he has been selected. I
Readings
got
are
a case
complete.
law, my lord.
Readings are complete.
Readings are complete.
Let him come.
Obliged, Lordship.
I got a case law in this regard. that
Also in this case, Lordship, the affidavit is yet to be filed by the respondent.
Mr. S.K. Das, counsel for the petition. On the, you want to file affidavit? No.
No, we haven't.
Do you want to file?
Some extra time.
On the request of Mr. S. Borua Learned G. Assam appearing for the state, this matter stands adjourned for 6 weeks so as to enable him to obtain instruction and file the affidavit. Is there any interim order in this case?
No, no.
Let the matter be listed accordingly. Yes.
Since my name was not on the matter escaped my notice, Lordship. I have received instruction from the department to file affidavit, Lordship. My lord, I appear for the entire issue has been concluded. It's an issue in a very narrow campus, short legal issue, decided by this honorable court, division bench of this honorable court, and now Supreme Court. My learned friend was present in July when the matter was heard at length before Justice Barua. Again, 11th of September, it was fixed. They asked for time. There's nothing to submit in the affidavit. If your lordship will be kind enough to enable me to explain in brief what the issue is, then I leave it to your lordship. He can take any amount of time for filing affidavit. My only submission is my refund, which has been held, which has not been granted to me, which has been granted to all other industries in the area. My refund should be granted. I undertake to give back the refund within 7 days. You can take your time to file the reply as long as you want. No issues.
Lordship, in this case, what happened, Honorable Supreme Court passes judgment, reversing the earlier judgment. Lordship.
May I just give the background, your lordship?
In view of that,
Let him make it submit and we'll hear you. Please. Appearance.
My lord, the issue pertains to levy of education cess. My lord, in 1997, an industrial policy was declared for the state of Assam in all the northeast area, that you set up new industries or you substantially expand your existing industries. We'll give you an exemption from excise duty for 10 years and from income tax for 10 years. That, as your lordship is aware, has led to such an industrialization here. This was further extended in 2007 for another 10 years. So people set up industries. We also set up industries. We put up 3 units, about 1,100 crores we invested here. Exemption was granted. In 2004, education cess was imposed, which was as a percentage of the excise duty paid and collected. So 2% of the excise duty paid and collected. So which was there since Northeast and many other areas in Jammu, Kashmir, in Kutch, exemptions were granted in similar manner. Submission was made that since excise duty itself is 0, 2% of 0 would be 0. That litigation went on, went up to Supreme Court in SRD Nutrients case, finally decided. If your lordship would just make 10/11/2017, SRD Nutrients decide the case, said, yes, education cess is not leviable. You must refund to them. And this, they are entitled for the refund because excise duty itself is exempt. You can't levy education cess. Then sometime in December 19, so the refunds were sanctioned and granted by the department. To me also, refunds were sanctioned. So sanction orders were passed in many cases. Then a second judgment came of the Supreme Court in case of Unicorn, when it was pointed out that SRD Nutrients, one of the judgments was not cited, and therefore their judgment is per incurium, which will apply only for the future matters. Based on that judgment, show cause notices were issued to me and many others in the Northeast under Section 11A, which permits the department to ask for return of erroneous refunds. Many industries challenge the show cause notice itself before this honorable court. Since I have been told many times that why are you challenging show cause notice? It is only a show cause notice. You give a reply. They might consider your reply. If then you are aggrieved, you come back. So I chose to reply. Many others chose to challenge the show cause notice itself on the ground that what you are entitled in 11A is to recover erroneous refund. This is not an erroneous refund. A refund granted in pursuance of a Supreme Court judgment is not an erroneous judgment. Therefore, the show cause notice itself is bad. The foundation is wrong. This honorable court, your lordship, 3 judgments I had handed over. Last time, your lordship will find it.
Yes.
Topsem India. There was a detailed order passed by Justice Barua, where all this is captured. Your lordship has the copy of the Topsem, otherwise I'll hand over your lordship. In fact, in a detailed order,
Must be there somewhere.
your lordship, a detailed order was passed where the stay was granted by Justice Barua. Your lordship has a copy of that order, otherwise.
I have an order passed by Justice Soumitra Saikia. Are you referring to that? 2021 to GMT?
That's right, your lordship. That is the judgment on 12th March 21.
by
Yes.
Justice Saikia in Topsem. That is the first judgment,
Yes.
where he decided that this is not an erroneous refund. The refund was granted in accordance with law. Therefore, 11A is bad. You cannot issue a show cause notice in 11A. Therefore, they're entitled for the refund. Can I just read a few paragraphs of the judgment, Your Worship?
So what is the order you are seeking today?
My order is this, Your Worship. So therefore, the refunds were granted. If I could just indicate to Your Worship. Topsem said show cause notices are bad. They filed an appeal before the division bench. That was decided in case of Keshri Industries. Your Lordship will have that judgment also. That's a judgment of the division bench, which approved Justice Saikia's judgment. That Keshri is a judgment by Justice Dhulia. And that approved, so that's a division bench judgment. They have decided not to appeal against that to the Supreme Court, so that's a final law decided. In the meantime, they moved an application to SRD Nutrients. They applied to Supreme Court for review. The review was rejected. They again moved an application for variation of that order, which also has been decided by Justice Nagaratna recently in July 2023. Your Lordship, that order Your Lordship will find. So the entire issue is now over. It's been given a quietus already. Your Lordship will kindly see if you have a copy, otherwise I'll hand over another copy, Your Lordship. That has been cited in the order passed while granting stay. All these have been mentioned by Justice Debashish Barua, Your Lordship. My Lord, got a copy of this order?
Yes, yes.
So it was a short order. May I just read, Your Lordship,
Yes,
of the
please.
Supreme Court?
Yes.
We have heard Mr. Venkatraman, learned ASG, appearing for the petitioners in extenso. He pointed out that this court, in the case of SRD Nutrients, reported in so-and-so, gave a ruling contrary to the judgment previously rendered by a three-judge bench at this court in case of Modi Rubber. In a subsequent decision, namely Unicorn, reported in so-and-so, the judgment passed in SRD Nutrients was overruled. It was held that the exemption from payment of excise duty and the notification granted would not exempt the payment of education cess and secondary education cess. It was also observed in the said judgment that the judgment passed in SRD Nutrients was per incurium. Learned ASG, during the course of his submission, has brought to our attention an order passed on 27/9, referring to the very decision passed in SRD, which has been overruled, to a larger bench, having regard to the fact that the said decision was per incurium in as much as it had not considered the earlier judgment of Modi Rubber. Therefore, he submitted that this matter has to be connected with the said matter and the judgment to be passed in line with Unicorn. We have given our anxious consideration to the submissions made by the London ASG in light of what has been stated by the High Court in para 74 of the impugned judgment. In SRD Nutrients, it was held that when payment of excise duty is exempt under the Central Excise Act, then the 2% education cess and secondary education cess payable on the aggregate duties of excise will also be exempted. However, later in the case of Unicorn, the aforesaid judgment in SRD was overruled, and it was held that although the exemption from payment of excise duty under a notification is granted, there is no exemption from payment of education cess. Therefore, the SSE who had paid the excise duty and education cess was not entitled to a refund of the education cess which had been paid. With regard to the reference order made on 27/9 on a miscellaneous application filed by the revenue, seeking to undo the judgment of SRD, which was overruled in the subsequent judgment of this court in Messrs. Unicorn. The question is whether there was a need at all to refer the matter to a larger bench. This is for two reasons. Firstly, such an application could not have been filed after the review petition in SRD Nutrients had been dismissed by this court. Thus, in substance, by filing the miscellaneous application, the revenue was seeking a second review of the said judgment, which is impermissible in Order 47 Rule 9 CPC. Secondly, by ignoring the explanation to Order 47 Rule 1 of the CPC and the principle that emerges from the same, what is sought to be contended by learned ASG is that if a judgment is overruled by this court by a subsequent judgment, then the overruled judgment will have to be reopened, and on reopening the said judgment will have to be brought in line with the subsequent judgment which had overruled. This is not permissible in law for two reasons. Firstly, there was to be finality in litigation, and this is in the interest of state. Second, a person cannot be vexed twice. This is epitomized by the following maxims. I'll skip that. These maxims would indicate that there must be an end to litigation. Otherwise, the rights of persons would be in an endless confusion and fluid and justice would suffer. That is why the explanation to Order 47 Rule 1, which is a wholesome provision, has been inserted to the Code of Civil Procedure. It states that once there is a subsequent judgment overruling an earlier judgment on a point of law, the earlier judgment cannot be reopened or reviewed on the basis of a subsequent judgment. The contention of the revenue is that in view of the subsequent judgment of this court in Unicorn Industries, recoveries could be made from the SSCs with regard to the refund of education cess made by the department, or if not paid by the SSC following the judgment in SRD. In the above circumstances, appeals were filed before the High Court by the SSCs. In the instance case, the High Court had raised the following question of law and answered it against the revenue. In our view, the High Court has rightly answered the aforesaid question. The High Court in the impugned order, while considering the judgment passed by this court in SRD Nutrients, as well as in Unicorn Industries, has observed in para 74 as under. Applying the aforesaid principle in these cases at hand, since the SSC has been held entitled to the refund of the education cess and secondary and higher education cess on the basis of a judgment and order of the Supreme Court in case of SRD Nutrients, which was in vogue at the relevant time, the appellants are not entitled to make a recovery of the said refunded amount on the basis of the subsequent decision of the Supreme Court rendered in the case of Unicorn Industries. If such an action is permitted, it will open a Pandora's box, and the list between the parties which had attained finality will never come to an end. This would be against the public policy, which envisages providing quietus to litigation at some stage. In substance, the High Court has stated that the decision in SRD has attained finality and was binding on the parties thereto. Therefore, the subsequent decision of this court overruling SRD in the case of Unicorn cannot have a bearing on past decisions which had attained finality, although they had followed SRD Nutrients, which was subsequently overruled in Unicorn. Otherwise, the Pandora's box would be opened and there will be no end to litigation, which is against public policy. That is exactly what is sought to be done by the reference order dated this. When we read the reference order in light of what has been stated, discussed, we find that the reference order was unnecessary. In the circumstances, the SLPs are dismissed. So this has been the final, Your Lordship. That is the law today. Now, before the AC, since others challenged and the matter came here in case of Topswam and Kesari, by the time my turn came to make submissions to the AC, Topsam had come, Kesari had come. I cite the judgments of the single judge and the division bench, binding on him. He shows the courage of quoting them, also saying they are binding, and yet decides against it and confirms the department. That is why last occasion when it came for admission, Justice Barua, Your Lordship will kindly see the order, passed and stayed the order. Now, my submission is everybody has got refund. My refunds of about 13.45 crores are held for no reason for all these years. I pay so much of revenue, part refund has been granted, and 13.45 you are keeping with you. Please give it to me. Like every other industry in the state has got it by virtue of Topsam and Kesari. Why deprive me? Please grant it to me. I pay you so much of revenue. Within 7 days of any adverse order, if ever it is passed, even if after it can be passed after Supreme Court judgment of this kind, I'll return it back to you. But they will seek some time, some reply. If Your Lordship will kindly see the Assistant Commissioner's order, it's a clear contempt of this Honorable Court, citing the judgment of this Honorable Court in Topsam, citing judgment of division bench, and still flying in the face. And also noting that you have decided not to appeal against the Keshri judgment to the Supreme Court. With great respect, Your Lordship, this Honorable Court will have a comment or two to make for the Assistant Commissioner that once we pass the order of this kind and they have decided not to challenge before the Supreme Court, even if they challenge, so what? You have to follow the law unless it is stayed by the Supreme Court. But in a case where you decide not even to appeal, how can you not implement? All I'm asking for is implementation of Your Lordship's judgment and judgment of the Supreme Court. So they can take any number of months to file the reply, no issues. Otherwise, the writ itself.
So are you willing to give any security, any bank guarantee or anything for the refund?
Undertaking, Your Lordship, 7 days you will refund. Your Lordship can note it with the bar. Within 7 days, normally it will be 3 days, Your Lordship. 7 days, I'll refund the money. No issues at all. I pay 1,100 crores of revenue to them. It's indeed sorry that I have to come here for 13 crores begging like this for a right which has been determined by all the courts.
May I submit, Lordship? Lordship, in earlier cases, refund was made to all the SECs, Lordship. On the basis of SRT, Lordship. SRT was held to be per inquiry by Unicorn, Lordship. Now, Lordship is to decide whether the petitioner is entitled to any refund after the Unicorn is.
Mr. Lodha, is it?
Yes, Your Lordship.
Mr. Lodha is submitting that you have already granted refund of many other.
Yes, Lordship, it was granted and we issued notice under section 11. That was held to be paid by the dishonorable court. We went to division bench, division also dismissed. Thereafter, we file applications in pending cases that has been decided against us also.
But there is no appeal against the division bench order.
Yes, Lordship, because Lordship Supreme Court has held in this case, Lord, division bench held that there is no retrospective effect of the Unicorn judgment. It will be prospective. On that point, it was decided against us. In the present case, Lordship, nothing has been refunded to the petitioner. In the meantime, Unicorn has come.
No, it has been refunded to me, sir. Please, factually only I'm pointing out.
In some cases, Lordship, now, Lordship, in view of the Unicorn, whether they are entitled to refund, Lordship, after Unicorn judgment, Lordship. Then as all the refunds were made on the basis of SRT, Lordship. And after Unicorn come, we issue notice to all the SEC to refund back the amount. Then this honorable court said that no, there is not retrospective effect of Unicorn. When you have made payment on the basis of SRT, that is final, Lordship. So, Lordship, now we have to decide whether they are entitled to any refund on the basis after Unicorn has come, Lordship.
That is
So,
exactly.
Mr. Lodha, the court has to pass a reasoned order here.
Yes, Your Lordship.
You may have to undertake one more journey, but we'll fix a date and we'll finish
Yes,
off the
Lordship.
matter on that day.
I have already received my instruction,
I
Lordship.
leave it to Your Lordship.
Because
And today,
we have to pass a final order here. This
Yes,
is
Your
an
Lordship.
interim order.
it can be decided on next day.
If you want the time, Your Lordship, they keep on seeking time, therefore I'm only.
No, we'll make it very clear.
Lordship, today,
No
Lordship,
further adjournment.
I am.
This will
Lordship,
be a fixed matter.
Today I'm handicapped because my name was in my department name was not
No,
shown.
that's,
why
I understand. That is a point the court will find it difficult
He is
to.
very fair otherwise also.
I have also seen. That is a ground we have to consider.
And on last
So
occasion.
can you both agree on a date after
Lordship,
the
23rd of November, 23rd of November.
23rd of November?
Yes.
All right. We'll make it very clear that next date matter
Yes,
will be
Lordship.
taken up
I'll
for
not seek
final
any
disposal. And there will be no prayer for adjournment.
I'll not seek any adjournment, Lordship.
Please,
All right.
grateful.
I will take down heard Mr. C.S. Lodha and his counsel appearing assisted by Ms. K. Bhattacharya, appearing for the lead petitioner. Also heard Mr. S.C. Kyle, Leonard Standing Counsel GST authorities who submits that he has received instruction in the matter, but since the name of the SC GST has not been shown in the cause list, he had missed the matter. Mr. Lodha, on the other hand, submits that this is a covered matter under the previous decisions of the single bench as well as the division bench of this court. And therefore, it is only a question of implementation of the orders of these earlier decisions of this court. Notwithstanding the same, the respondent authorities are arbitrarily denying refund of educational cess
Education says.
to the petitioner, although other similarly situated entities have already received the refund. Mr. Lodha therefore pays for expeditious disposal of the writ petition. Having heard the submission of learned counsel for both the sides and on going through the materials available on record, this court is also of the opinion that The writ petition calls for expeditious disposal. As such, on the request of Mr. C.S. Lodha, learned counsel for the petitioner, this writ petition is directed to be listed again on 23rd November 2023 as a fixed item for admission hearing. The respondents may file affidavit in the matter on or before 14th November 2023.
It's already ready. If they can give it to me, I'll decide whether to reply you.
I'll within a week, Lordship, I'll file.
Within a week from today,
Yes, sir.
by serving advance copy upon the petitioner's counsel. It is made clear that in view of the nature of controversy involved in this petition and the urgency expressed by the learned counsel for the petitioner, no prayer for adjournment will be entertained on the next date fixed.
What's in my name may be reflected.
Register to list this case by reflecting the name of learned SC GST in the cause list.
Oblige, Your Worship. Grateful. Thank you so much.
May it please, your Lordship. Lordship, this is a case where my NGO, which is running a halfway home for mentally ill person, it has been sealed 5 months back without any authority of law. While issuing notice, your Lordship has directed them to produce relevant instruction and on different dates, your Lordship, they have taken time. Absolutely, Lordship, this is a case, your Lordship, where there is absolutely no law which permits sealing of a compass or a immovable property by any authority, more so after passing of the judgment by the Honorable Supreme Court, saying that the police has no authority under the law to seal or seize any compass. Lordship, I just put the facts in brief, your Lordship. This petitioner, your Lordship, is an NGO and they have been designated by the government as a designated NGO to run a halfway home for mentally ill persons at page number 13, annexure 1. This.
Have you filed affidavit?
In fact, my affidavit is ready. So once the officer comes, I will file the detailed affidavit. So let it be by next week, I will file it.
Have you
Things
filed
will
the
be clear.
affidavit?
Already the stand has been taken.
Mr. Counsel for the petitioner also heard Mr. S. Burwal and G. Assam appearing for the official respondents who submits that his affidavit is ready.
Ready.
He submits that affidavit on behalf of the official respondents is ready and shall be brought on record within a week's time. Therefore, a prayer has been made to adjourn the matter for 10 days. Taking note of the submission of Mr. Burwal, this writ petition is directed to be listed again after 10 days. In the meantime, affidavit on behalf of the respondents be brought on record by filing advance, by submitting, by furnishing advance copy upon the petitioner's counsel.
Date, your Lordship.
10 days, after 10 days.
It will go after vacation then.
Yes, yes. Why vacation? After 10 days is not vacation.
Then your Lordship may fix a date because it will come as motion days will start, your Lordship.
Sorry?
Motion days will be given last week of the vacation. Generally before the last week is given as a motion day. So this matters.
That means only motions will be taken up.
But if we also
When
make,
did you join practice?
no, even if we make a mention before the registry there, so that no, will not give, unless there is a fixed matter, we will not give.
I have passed the order, you read it whenever you get.
Oblige, Lordship.
All these submissions are meaningless. The fixed item. As a fixed item. Yes.
May I please, Your Lordship? So this matter relating to a railway accident, Lordship. Railway accident regarding the compensation, Lordship.
Lordship, as per the railway accident and untoward incidents compensation rules 1990, Lordship, there is a schedule when the date occurs, Lordship, the compensation amount is 8 lakhs. Lordship, for getting the benefit of the compensation amount, firstly, Lordship, he has to satisfy that there was an accident, Lordship. As per the definition of.
Wait a minute, what is this matter about?
Lordship,
What is this matter about?
compensation for death of a person over a unmanned Lordship, that railway crossing, Lordship.
So this matter has not gone to the Railway Claims Tribunal.
He is not a
He
passenger.
is not a passenger. But as per this act, he has to be a passenger to get the benefit.
Then what has happened? The person has died.
Already died. He is a secondary education department teacher. all petitioners are his legal heirs.
Who has died? Who has been killed here?
Lordship, petitioner's husband died.
Have you filed your affidavit?
Lordship, no, we're fine, Lordship.
Let him file his affidavit. This is a 2023 matter. It has to come after vacation.
They are in a very financial crisis. They have no any other income source also. So
Oh, it will take a long time. Financial crisis cannot be, the court passes a judgment in your favor. Then also they'll prefer an appeal probably, and if they do it, then it will take time. Financial crisis cannot be, there has to be determination of liability and compensation. This can't be the ground. We can't decide these matters day after tomorrow and you get the money next week. Heard Mr.
fix the matter.
B. Cycle and counsel appearing for the writ petitioner. Also heard Mr. C.K.S. Borwal and the CGC appearing for the
All present.
respondent who submits that 6 weeks further time is required to file affidavit. Prayer is allowed. However, if no affidavit is filed within 6 weeks as granted by this court, this matter will be taken up for disposal on the basis of materials available in the court. On the request of Mr. C.K.S. Borwa, this writ petition is directed to be listed again on 21st of November 2023 as a fixed item.
Obliged.
Binding matter item 31.
No, we'll finish up first, entire list.
Senior counsel has not come, though. Should we take it up?
Orders item 36.
Madam, Ranga has to apply the court my lord regarding my arrangement before demolition of the house market. Last order, my lord.
Service complete on respond number 4. Let it be listed for admission. Heard Mr. A.J.R. Taylor, counsel for the writ petitioner, also heard Ms. S. Borwal and G. Assam appearing for the respond numbers 1, 2, and 3.
1 and 2.
1 and 2. None has appeared. 1 and?
3.
Why not 2? Who is appearing for Director Municipal Administration?
Lordship, sorry, observe Lordship, 1 and 2, I am appearing for 1 and 2. 3 municipal board, Doboka Municipal Board will be appearing for respondent.
No, but government advocate has accepted notice for 1, 2, and 3. Why have you accepted notice earlier?
Yes, Lordship, I can.
1, 2, and 3. Office note dated 13/9/2023 goes to show that service of notice upon respond number 4 is complete in this case. As such, register to verify if any counsel has entered appearance for respond number 4 and list the matter for admission by reflecting the name of counsel for all the sites in the court list. Yes.
Item
All right.
47 to 38.
May it please the Lordship. Lordship, in item number 37 of by office note dated 30/08/2023, it has been stated, Lordship, that since their implement application was allowed, the petitioner was required to file an IF order implement in the writ petition. Lordship, it has been, the office note has been stated in compliance to a notification. It is there, Lordship, as marked as X. Lordship, since we are under the idea that we are not seeking any changes in the cost title, the registry would do the needful. We didn't find.
No, cost title you have to file, registry will not file.
Okay, Lordship, we need some time to file the IM.
Pursuant to the implement, no cost title, no fresh cost title has been filed in this case. As a result of which the matter could not progress further. First of Miss
A.N. Hussain on behalf
A.N.
of S. Ramil.
Hussain, learned counsel appearing for the petitioner prays for 10 days time to file amended cost title in the writ petition. Mr. L. Mohan, learned counsel for the respond number.
Eight. Newly.
Respond number 8. Ms. N. Bodole, learned SC revenue for respond numbers 2 and 5, Mr. S. Borua, learned G. Assam,
Now the fishery is having their own set of council.
learned G. Assam is present. Mr. L. Mohan, learned counsel for the respond number 8 is also present. On the request of Ms. So-and-so, learned counsel for the petitioner, this matter stands adjourned for 2 weeks so as to enable her to file amended cost title. Please take over.
In item 38, I am the petitioner.
Item 13.
Item 38, I am the petitioner.
And item 38, so-and-so for the petitioner, so-and-so for the respondent. List this matter along with item 37. List this matter again along with item.
Malad, the matter list the suspension of Panchayat Secretary Malad. He respond number 2, 3 and 4 file affidavit in opposition Malad. 1 week time will be granted to file agenda.
Mr. D.K. Das, learned counsel for the petitioner prays for and is granted 2 weeks time to file counter affidavit in response to the affidavit, rejoinder affidavit in response to the counter affidavit filed by the respond numbers 2, 3 and 4.
RB Goswami.
Mr. R.B. Goswami, learned counsel is present on behalf
2, 3 and 4, my lord.
respond numbers 2, 3 and 4. Ms. S. Burwa, learned G. Assam is present on behalf of respond number 1. Let the matter be listed again after the reopening of puja vacation.
All right.
Item 14.
May I please your lordship? Lordship, respondent number 3 filed a affidavit in opposition. So we need 1 week time for reply.
All right, the learned counsel for the petitioner, Ms.
As does.
As thus prays for and is granted 2 weeks time to file rejoinder in response to the counter affidavit filed by the respond number 3. Who are appearing for the
I am for respond number 3 and 5.
Ms. S. Borua, learned G. Assam is present on behalf of respond numbers 3 and 5. Whereas
Respondent number 6, W. Ahmed on behalf of B. Chaudhary.
who is the excise counsel? Where is Mr.
Respondent 1 in.
I. Botaku,
Yes.
learned SC Excise Department Assam is present on behalf of respond numbers 1, 2 and 4. Mr.
W. Ahmed on
W.
behalf of
Ahmed
B.
is
Chaudhary.
present on behalf of the respond number 6. On the request of the petitioner's counsel, let this matter be listed again after the reopening of puja vacation. In the meantime, rejoinder be brought on record. Rejoinder affidavit.
Lordship, in a tender process, we have participated regarding lots of parking space in jail, old jail complex. And 3 highest
Tender
bidder.
is not this bench. Tender is bench 4 matter.
Yes.
Tender is not bench 5 matter. But anyways, what is there artists in this?
Now, Lordship, my submission will be Lordship. I am the 3rd highest bidder. First highest bidder was offered. I have challenged his selection and appointment on the.
I'm
ground.
hearing this only to decide whether it
Lordship.
should be posted next week or after 2 days. That's the reason. This is not a bench 4 matter, bench 5 matter.
My submission will be Lordship, in this case, Lordship. And I do not any specific order. I want that Lordship, already the highest bidder who has allotted the work order, he has not failed to give the bid security. That is withdrawn. Second also failed, Lordship. And the third highest bidder. Only thing is, Lordship, now they can go for the fresh tender. Otherwise, Lordship, the matter is pending for long period from 2020.
So you obtain instruction and registry will list it before the appropriate bench on Friday.
Lordship,
Yes.
for and the back.
Heard
Our
Mr. S. K.
activity is
Goswami,
on-
learned counsel for the petitioner, also heard Mr. P. Nayak, learned SC PWD Assam appearing for the official respondent. It appears that this matter pertains to civil bench 4, but has been wrongly listed before this bench today. As such, the registry to list this case again on 13/10/2023 before the appropriate bench. In the meantime, Mr. Nayak
File, Lordship.
to
Already
obtain
filed,
instruction
already filed, Lordship. It
and
is a
appraise this court as to whether, in view of refusal on the part of the L1 and L2 to execute the contract.
Lordship may not observe that, just simply because he quoted Lordship less than the bid value, reserved bid value, Lordship.
Whether the work can be awarded to the petitioner in view of failure on the part of the L1 and L2 to execute the contract. You just obtain instruction, you say yes or no, that's it. If you say no, then if you say yes, matter can be closed.
Lordship.
If you say no, it will be decided on merit. Yes.
Obliged.
On a contact case, notice was issued today is the first day after issuing of notice.
Lordship, I'm appearing for respond number 1 and 2. I've received the pairwise comments, Your Lordship. I'll file my affidavit.
Right.
With
Mr.
3
M.
weeks
Sharma,
time.
counsel for the petitioner also had Ms. N. Bordole, learned counsel appearing for the respond numbers 1 and 2, who submits that she has received instructions and therefore be granted 2 weeks time to file affidavit.
Lordship,
Uh,
Grant me 3
how-
weeks time, Your Lordship.
2 weeks will make it 4 weeks. Don't
After
worry.
puja vacation.
Yes, yes.
Yes, sir.
Date may be fixed, my lord, if possible.
In view of the prayer made by Ms. Bordole, this matter is directed to be listed again in the second week of November 2023. In the meantime, affidavit on behalf of the respondents be brought on record. Yes.
And
I'm obliged.
May I please, Your Lordship? Lordship, although the office note dated 28/9 says that neither AD nor out of notice, but causely shown the name of the.
You are appearing.
I'm appearing for the sole condemned.
All right. What is your stand? Why the order has not been complied with?
I have to receive the instructions.
Heard Mr. I.
Hassan.
I Hassan, learned counsel for the petitioner. Also heard Mr. Aram Das, learned counsel appearing for the sole respondent, who seeks 2 weeks further time to obtain instruction and file affidavit if deemed necessary. In view of the above, register to list this matter again in the second week of November 2023.
All right.
Item 44.
May I please, Your Lordship? I am on behalf of the contempt respondent. So in this case, payment was already made. Payment.
Have you received instruction?
Yes,
Order has been complied with.
yes.
None appears for the petitioner when the matter is called up. Mr. A. L. Mondal, learned counsel. Appearing for the sole respondent stroke contender has appeared and produced a copy of the communication dated 11/9/2023 to submit that the order of this court has already been complied with. I have perused the communication dated 11/9/2023 issued to the petitioner. Which goes to show that the net claim under the policy for an amount of rupees 1,60,094 has been credited in the UCO Bank account of the petitioner. If that be so, nothing is further advised in this case by retaining a copy of the communication dated 11/9/2023 in the record of this case. This contact case stands closed. Yes.
Highly.
Item 45.
Yes.
Lordship, I have filed my wakalatnama for both the respondents. And within next 7 days, Lordship, the order will stand complied with. So I might be granted sometime, Lordship.
Mr. A. Dekar, learned counsel is present for the petitioner. Mr. D. Saraf, learned counsel is appeared for the respond numbers 1 and 2 and submits that within a week from today, the order of this court will be complied with. In view of the above, let this case be listed again after a week for orders.
Obliged, Lordship.
Item 46.
Please, Your Lordship. We were directed to take steps in with respect to respondent number 4. Your Lordship, service has been completed with respect to respondent number 4. And pleadings are also completed, Your Lordship. I requested the. How many respondents are there in total? 4, Your Lordship. And who is appearing for 1, 2, and 3?
I'm for PNB, Your Lordship. Punjab National.
But I'm asking, you are appearing for which respondent? 1, 2, and 3.
1, 2, and 3.
1, 2, and 3. Mr. Datta, you are there?
Yes.
Acha, acha. And 4 has been served, is it?
Yes, your lordship, it has been completed.
So let it be listed for admission after
Yes, sir.
vacation. Heard Mr.
N. Datta.
And in Datta, learned counsel for the writ petitioner also. Heard Mr. S. Datta, learned senior counsel listed by Mr.
K. Upamanyu.
K. Upamanyu. Learned counsel appearing for the respondent numbers 1, 2, and 3. Office note dated 1/4/2023. Not 1/4. 2/5/2023 indicates that service of notice on respondent number 4 is complete in this case. In view of the above, register to verify as to whether any counsel has entered appearance for respondent number 4 and list the matter thereafter. And list the matter after reopening of puja vacation by reflecting the name of learned counsel for all the parties in the list.
Obliged. Your lordship, if a date may be fixed.
After puja vacation.
Item 47.
Obliged.
And a small correction matter in the order, my lord, page 23,
Heard Mr. B. Sinha, learned counsel for the
fifth
applicant.
line.
His IA has been filed seeking correction in the order dated. In the 5th line of the order dated
4/8/23. 1/4 or the old and
Oh,
763
this has to go before the concerned judge.
concern.
Uh, Correction in the order dated 4/8/2023 passed by the learned single judge in WPC number 4225 of 2023. Let this matter be listed before the appropriate bench. Bracket. Name of the judge, Justice Manish Chaudhary, Honorable Justice Manish Chaudhary.
Supplementary list item 48.
Wait, please, Lordship. This has been remanded back, Lord, my friend, they have challenged it before the writ, in a writ appeal. It was remanded back on the ground that they were not heard. That was the.
I am representing defendant number 5. I have just filed my wakalatnama actually right now, sir. Actually, in the last read, actually, defendant number 5, 6, and 7 were not served any notices. So we had filed the writ actually, appeal.
This has been remanded back.
It has been remanded back, but in after your lordship's order, this order has already been carried to its logical.
Which is the order?
One of lordship's order is of 4/8/23 minutes.
So he has entered.
Yes,
Let
I
him
want-
file his affidavit. Heard Mr. Ganguly, learned counsel. appearing for
Evidence
the
in
writ petitioner.
affidavit I will give in the
Also
next
heard
date.
Mr. I.S.
Majumdar,
Majumdar, learned counsel appearing for the
defendant number 5.
respondent number 5, who prays for and granted 3 weeks time to file his affidavit. Let
Lordship.
the matter be listed again after 4 weeks.
Complex.
Lord, I may be permitted to take steps on 6 and 7.
In the
This is
meantime,
only for-
the petitioner is granted leave to take steps for service of notice upon respondent number 6 and 7 by registered post with AD,
Complex.
making the notice returnable in 4 weeks.
Item 49.
May it please your lord.
Notice was issued, but no.
My lord, here social justice empowerment is the main party, my lord. They are the one. They were not served the copy. I have just informed my friend.
I have not been served a copy of the petition.
They are the one who is taking care of this department, man. This issue.
They are parties.
They are parties, respondent number 4.
I serve for.
What is the matter about?
My lord, is my lord, the Maimal committee regarding issue of obvious certificate, man.
So he will need some time to obtain instruction. We'll have it after vacation.
Yes.
Heard Mr. Giudice, counsel for the petitioner, also heard Mr. Ardhar, standing counsel
WPT and BC, madam.
WPT and BC. Mr. R.M. Das, Lanet, Standing Council, Social, Department of Social,
Social Justice and Empowerment Department.
Lanet Standing Council, Social Justice and Empowerment Department submits that no copy of the writ petition has been served upon him. In view of the assurance given by the petitioner's counsel to serve copies of the writ petition upon Mr. Das within 3 days from today, let this matter be listed again after reopening of Puja vacation, so as to enable Mr. Das to obtain instruction and file it.
Item 15.
May I please, your lordship. Lordship, as per your lordship's direction, we have filed a amended petition on 7/10, your lordship, but the same has not come on record, lordship.
Amended writ petition, is it?
Yes,
When did you file it?
lordship, 7/10/2023.
Have you received copy of the amended writ petition?
No, my lord.
Lordship, we had given the copy, lordship, but somehow
Mr.
HR does.
HR does not counsel for the petitioner submit that amended writ petition has been filed on 7/10/2023 in this case, but this name is not on record. Mr. DP Bora, Lanet counsel appearing for the respondent numbers.
Respond numbers, my lord, all the 1 to 3, 4. no? 1 to 6.
The respondent numbers 1 to 6, 1 to 5 submits that no copy has been served upon him. No copy of the amended writ petition has been served upon him as well. In view of the above, let this matter be listed again after reopening of the Puja holidays by tagging the amended writ petition with the record of this case. Within 3 days from today, a
Yes,
copy of the amended writ petition be furnished to Mr. Bora, so as to enable him to obtain instruction and file affidavit if so desired.
Obliged.
File being matter, item 41.
But in a draw of lots, Malat, he was selected for that retail outlet. And ultimately, my lord, that your lordship will get 105, page 1.
So we'll take it up at 2, it will take some time.
No, it will not take time. Hello, whether only he's an executive.
Are you considering his case?
No.
Then how do you say it will not take time?
Okay.
You cannot conclude it now, so.
Yes.
But what is it by draw of lots?
He was selected, my lord,
Selected for what?
for the retail outlet, oil,
All right,
oil.
which place is it?
That is at page 105, 106.
Okay,
Then it was cancelled on the ground that he's an employee. He's a nominated member of the council,
nominated member of which council?
Karbi Anglong Autonomous Council.
All right,
So
so that
he's
was
an
the ground
employee.
why it was cancelled.
He's an employee. They say he's an employee. So therefore, it is cancelled. And that needs a full-time job, maintaining a retail outlet. And he's an employee. So therefore, so my Supreme Court judgment is there, whereby it says MLA MPs are also not an employee. There is no relationship between employer and employee. So therefore, my lord, if he is not an employee, he is entitled to get the definition. He is nominated member. He can be ousted any moment. And as soon as the term expires, it goes. He is not an employee for any purpose. That 2000, that Supreme Court judgment, my lord.
Is your client willing to resign for this?
No, he is not willing to. He is a nominated member, man.
What is
It
your
is not
stand?
required.
Our guidelines say that you cannot be an employee and you cannot draw salary. Now he has relinquished his salary. But what I will point out is the dates that when he filed the application and till the date on which his candidature got confirmed through the draw of lots, he was, and much beyond that also, he was in he was a member. He took up the job,
Nominated member.
giving an affidavit while applying that I will not do so. He took up the job, he was receiving the salary. Once he became aware that and he got certain that he was selected, then he just relinquished the entire amount.
It's
No,
not
he
a
cannot
short
have
matter,
a-
Mr. Das. It will take some time. Because both, it's a contested matter.
Well, I'll just show one judgment. I think your lordship will consider at 2 o'clock. 2 o'clock, your lordship. On the page 105.
Just a minute. Yes. Now look, page 105, where this is where in a draw of lots, page 105. This is the name. Name of the petitioner.
That's all right. Draw of lots is not the issue. Issue is whether being a member of the council.
Page 38. Page 38, that is the reason they are saying. Clause 6. A person selected for the dealership shall be paying attention towards day-to-day working of the dealership by personally managing the affairs of the dealership. She will be eligible for taking up any, not be eligible for taking up any employment. If the selected person is already employed, or she will have to resign from the employment and produce the letter of acceptance of resignation by the employer before the issuance of letter of appointment by the OIL. Now, please 111. Page 111. In the second paragraph. During the field verification of credentials on 8/12/22, it is established that you are a member of Karbi Anglong Autonomous Council. As per dealer selection guidelines dated 24/12/18, selected candidates will not be eligible for taking up any employment if the selected candidate is already employed. She will have to resign from the employment and produce letter of acceptance and of resignation by the employer before the issuance of letter of appointment by the company. Like you have submitted order dated so and so issued by the Karbi Anglong Autonomous Council granting approval for voluntary relinquishment of monthly salary made by you under the extant industry dealer selection guidelines. There is no provision for award of dealership to any individual for surrendering of benefits like salary, parks, emoluments from the central state government, while the said individual continue to be an elected representative. So this is the case, my lord. Then we have filed a representation saying that I am a nominated member. That is at page 112.
So what is employment? Has it been
Yes,
defined anywhere?
that is there, my lord. This is the only clause. If for an
What
employee
is the definition of employment? Is it-
employment, my lord, I got a my lord, judgment, 2000 your lordship. Even MLA MPs are now not considered as an employee. My lord, this was a PIL file, para 1, PIL file for prohibiting MLA MP from practicing my lord law because they are employees. Now, para 15, your lordship state where I can take your lordship to this paragraph. May I read, my lord, para 15? The elucidation by the 3-judge bench of this court referred to above is irrefutable. The question, however, is whether the restriction imposed by the Bar Council of India under the rules as framed encompasses the elected people's representatives or legislatures. As aforesaid, the closest rule framed by the Bar Council of India is Rule 49. However,
Rule 49 applies whether an advocate is a full-time salaried employee of any person, government, firm, etc., corporation or concern. Undoubtedly, legislatures cannot be styled or characterized as full-time salaried employees as such, much less of the specified entitled. For there is no relationship of employer and employee. The status of the legislature, MLA, MPs is of a member of the House of People, House of Assembly. The mere fact that they draw salary under the 1954 Act or different allowances under the relevant rules framed under the said Act does not result in the creation of a relationship of employer and employee between the government and the legislature. Despite the descriptions of payment received by them in the name of salary, indeed the legislatures are deemed to be a public servant, but their status is sui generis and certainly not one of full-time and salaried employee of any person, government, firm, corporation, or concern as such. Even the expensive definition of the term person in the General Clause Act 87 will be of no avail. The term employment may be an expansive expression, but considering the constitutional scheme, the legislatures being elected people's representatives occupy a seat of parliament, legislative assembly, or council as its members, but are not in the employment of, or for that matter, full-time salaried employees as such. They occupy a special position so long as the House is not dissolved. The fact that the disciplinary or privilege action can be initiated against them by the Speaker of the House does not mean that they can be treated as full-time salaried employee. Similarly, participation of the legislature in the House or the conduct of his business by no standard can be considered as service rendered to an employer. One ceases to be a legislature only when the House is dissolved or if she resigns or vacates the seat upon incurring the disqualification to continue to be a legislature. But no standard thereof, Rule 49 as a whole can be invoked and applied to the legislature. Resultantly, it is not necessary to dilate on the question as to whether the nature of the duty of the legislature is such that it entails into a full-time engagement and that the person concerned will not be a person positioned to pay full attention towards the legal profession. That is a matter for the
Mr. Das, now I must point out one thing. This judgment has got no bearing in your case. This is the first thing. If you're relying upon this judgment.
No, I'm saying only for the purpose of the legislatures are not an employee.
All right, that doesn't matter because that case was whether they could practice and in the light of Rule 49. But here we are concerned with the relevant clause of the
that is page 38,
which says should not be in employment.
Yes.
But it also says one thing, that the dealer must personally manage the outlet himself. So therefore,
your lordship knows, my lord, the retail outlets, I can be.
let me put the question. That will be easier for you to handle. Otherwise, as a member of the council, he has to attend several meetings. There will be some engagement, is it not?
Some engagement will be there. Definitely.
Now, please come to, we have to answer your issue in the light of this clause
page 38
in the guideline, not this judgment. This judgment has nothing to do.
Only as regard
because that is a 49 rule, 49 was interpreted. And it says full-time employment. They are not in full-time employment. That's what the answer is given. But here the question is not whether a full-time or part-time employment. The question here is, please read clause 6 again.
Yes.
A person selected for dealership shall be paying attention towards day-to-day working of the dealership by personally managing the affairs of the dealership. He/she shall not be eligible to take up any employment if the selected person is already employed. He or she will have to resign. Now, there are two parts to it. One part is employment. That obviously, if there is an employment, then he or she has to resign. In your case, let us take it that it is not an employment per se, but it is still an occupation. He has taken up an occupation, is it not? he will have to discharge some duties as a member.
His occupation.
Correct. So what are his duties as a member? What are the duties?
Duty, in the affidavit, they said,
No, as per you,
Sometime meeting, I'm required to attend meeting and.
where can one find it? Where is that? Where are those documents, materials?
That documents are. And when my duties as a nominated member, I'm required to attend the house whenever the house is called for. This is the most important thing.
So these things will be necessary to say that this clause doesn't come in the way.
Yes.
We can't say that unless these materials are there. But this judgment,
Only for the purpose of showing that the legislatures are not employed. For the
that's all
second
right.
part, for the second part.
They are not, these are not considered as office of profit. All these judgments are there. But
Well,
here
I'll-
the
if you're
question was whether they are in full-time employment. And
I'm
to
not
that
sure.
extent,
They
whether
have
they
filed
can
an
be
affidavit.
allowed to practice advocacy, profession of,
That is that.
that was the question there.
That was it.
This is not the question here.
Only for the purpose of.
The question here is, despite being a member of the council, nominated member, can your client still be managing the day-to-day affairs of the pump? If so, what is the material to?
I can, if your lordship wants, I can file an additional affidavit showing what is my duty as a nominated member.
That is what you have to do.
I'll give
Then
that.
only we can pass a judgment, and otherwise how do we pass a judgment?
Soon
You
after
can
the
show that,
vacation,
and
the
if they are
council
unable
also
to,
may- Council may also enlighten on that one.
council
I can do it. I can
will
do it.
not, you will
Because
be,
they will have to ultimately say yes or no.
No, no.
I'll do it, definitely I will.
no, I've understood. What I'm saying is, your argument, as I understand, is that being a member of the council, nominated member, it is not any occupation at all.
It is not an occupation.
It is just an affiliation to a body.
Yes, and I'm not.
But
taking-
where are the materials to substantiate
My
that?
lord, your lordship will kindly see there, the letter given by the council,
No, that will not be
that
sufficient.
representation.
What are the
and their
rules?
affidavit.
What are the rules pertaining to duties of the council, nominated members, etc., etc.? These are the things
I'll provide this.
you have to bring on record.
Additional affidavit.
Without that, how do we record a finding?
Yes, I'll do. Soon after vacation.
Soon after vacation. Let him file an additional affidavit. Mr. B.D. Das, Lanet Senior Counsel. Assisted by Mr. H.R. Das, Lanet Counsel, appearing for the petitioner. Raised for 4 weeks' time to file an additional affidavit on behalf of the writ petitioner, bringing on record materials to demonstrate that being a nominated member of the in the way of managing the retail outlet on day-to-day basis. Also, since the prayer made by the petitioner's counsel is not opposed, same stands allowed. Register to list this case again after the additional affidavit is brought on record. The
After the vacation, any date,
you file it tomorrow, it will be brought day after tomorrow.
I'll try to file it.
But before vacation, he would also like to take,
Yes, yes.
so the respondents may file rejoinder if so advised. We'll take it up, but the point will be that,
My lord, I
That
have
will be
argued
the
on the
only point.
nature of work.
because it is
That
not,
portion I'll- Yes,
if the question is he in employment, the answer is no.
yes. Yes.
But having held that, we have to overcome this barrier that he has to be able to manage it on day-to-day basis.
In fact, my lord,
That's the key question.
yes,
Otherwise, he is not in employment.
the judgment which was placed by my learned senior itself says the nature of workman. So that is what I will be arguing.
Nature of work is what
Yes.
matters. And for that, the materials have to be brought in. You also find, we'll take it out after vacation. And dispose it off. All right. You are appearing for? अच्छा तेरे लोगों को नाम दीजिए वो मिस्टर पी भारद्वाज लानेट SC IOCL
1 and 2.
for respond numbers 1 and 2 and Miss P Shori Lanet SC KAC for the respond numbers respond number 3. There must be some other judgments on this.
I did not find exactly on this, but your lordship knows, nobody looks after any petrol pump giving 24-hour service.
No, that kind of
That is what everybody manages by.
That is another matter. In the court of law, you are assailing their decision.
Yes.
What happens in reality, everybody knows. But they are stubborn on this point. The court has to give a judgment on the basis of
That you,
issues raised.
supposing if somebody gets a, my lord, to run the petrol pump, one has to run it. manage
Then
it
why do you
20
bring in, if you want, if you are claiming principle of parity, bring in instances,
I'll bring.
we'll ask them. Has any
Nobody
other
can-
member,
Nobody can run two outlets.
no, is a MLA or MP being given a petrol pump?
One
dealership?
executive member, I was told it.
Then you bring it on record, we'll ask them how it has been given,
I'll try to.
how that person is running day to day. What I'm saying is bring the materials on record.
I'll
Otherwise-
bring at least the what occupation he is. He hardly is always free, my lord.
The
Hardly referred to.
spirit of this retail outlets and dealership is for employment to those unemployed.
He is unemployed only.
That's why these clauses are
Tomorrow-
brought in.
So what is the amount he is earning every month?
He's not earning any.
That might be zero, my lord.
Then
But again.
you
it's-
call someone earning zero as an employed person? See, the moment he brings the materials, the judgment is coming.
Right.
It's just that the materials are not there today. These are all. You have made him give up his earnings from the council also.
No.
Yes, yes. That is as per their advice, only I'm telling your lordship, my lord. But anyway, he's not drawing. That certificate has been.
That's correct, but Mr. Das, the point is not any of this. The point is, what is his nature of occupation?
I'll give.
Which shows that he
Has
can
fallen
run
from your
the,
lordship, my lord. I-
if necessary, he can run it on day-to-day basis
Yes,
for months and years together.
yes.
That is the point. Whether it is done actually or not is not the point.
I understand.
All right.